Appellants, court rise. Hand down judgment in Defoding and Royal Mail Group Limited.
For the reasons given in the judgment, which I now hand down, the appeal is allowed. The order of the Employment Appeal Tribunal will be set aside, and the judgment of the Employment Tribunal restored. There will be no order as to costs. Any application for permission to appeal to be in writing within 28 days of the date of this order.
Appeal in Balajigari and others, and Secretary of State for the Home Department.
Good morning, and may it please you, my lords. I appear on behalf of Mr. Balajigari. Can I deal with appearances in all of the cases? My learned friend Mr. Singh appears on behalf of the appellant Mr. Albert. Mr. Alexis Slatter appears on behalf of the appellant Kawos and the other appellants in that case. Mr. Sharaf Karim appears on behalf of the Majumder, in the Majumder appeal on behalf of Mr. Majumder. My learned friend Ms. Julie Anderson appears for the Secretary of State in the Balajigari, Albert, Kawos and Majumder appeals. And my learned friend Mr. Zayn Malik appears in all of the appeals except for the Balajigari appeal on behalf of the Secretary of State. My learned friends Ms. Sonali Nayak QC and Ms. Maha Sada, appear on behalf of the proposed interveners, Migrants Resource Rights Network, and they have an application that needs to be dealt with at the outset of these proceedings. So, my lords, unless you have any questions for me, what I propose to do at this stage is to give way to my learned friend Ms. Nayak QC, who will present the application
Well,
on behalf of the intervention.
I don't have any questions for you, but I have some things that we want to say at the outset which are relevant to Ms. Knight's position. The first thing simply to note is that the appeal is being live streamed while that red light is on. I don't think that means any difference to how any of us conduct ourselves, save that I can't quite see who it is at the far right-hand corner of the back row. Is that Mr. Slatter? Yes. When Mr. Slatter comes to address us, he may have to move because the camera won't pick him up there. The first thing I want to say is that we are concerned about time. There are a large number of both general and specific issues. Council will have to be very focused and succinct if we're going to cover all the ground. We will want to concentrate principally on the general issues, which it is crucial that we understand thoroughly. If we find ourselves short of time, the part of the case will have to be abbreviated. It is the facts of the individual cases, two of which, as it turns out, are academic anyway, and all of which, with some minor variations, fall into a particular pattern. So we don't expect to need to be addressed very fully on the facts of the individual cases, which are in any event well covered in the skeletons. So can I make that point? Have the parties agreed a sensible timetabling arrangement which will make sure we finish comfortably in the time available?
My lords, yes, as directed, the appellants have liaised between themselves and have allocated time between themselves and particular aspects of the issues to be covered.
That sounds very sensible. No need to give us the details, but what's the broad outline in terms of when the appellants expect to finish and the...
Well, we hope to finish within, well, certainly by the end of today and hopefully significantly before the end of today. The broad outline, I'll go first and I'll deal with the majority of the general issues. I hope I should complete my submissions in 2 hours, perhaps slightly longer than that. Mr. Singh from Mr. Albert will then pick up where I left off and will deal with particular points that haven't been covered by my submissions, specifically the Tameside arguments and issues arising out of HMRC's involvement and the suggestion that there may be some duty of comity between the public bodies involved in these cases, and there may be other points too that he wishes to develop, and the remaining counsel dealing with the other two cover any specific issues that concern their particular cases, and there are differences in the facts.
Well, okay, I think that's enough to be going on with. Thank you. It sounds as though you've thought about it, but experience shows these timetables don't always work.
Yes.
And what I said earlier about where the balance of the submissions should be borne in mind. I have to say that our ability to prepare effectively has been impeded by the way in which this case has been prepared by all parties. We have not found it helpful that despite my Lord's directions, we have had separate skeleton arguments and very full separate skeleton arguments for Mr. Albert and for the Secretary of State in Balajigari. No sensible explanation has been given for that. The skeleton arguments are far too long, really far too long. You should all be aware that the limit in the practice direction is 25 pages. But Mr. Albert's alone is 68 pages. The other respondents, I won't go through the numbers, you can see it for yourself. There's been no application to be dispensed, to have the limit dispensed with. If it had been made, there might have been some adjustment to reflect the fact there are 4 cases, but even so, skeleton arguments of anything like this length would not have been allowed. And I'm not going to spend time on this because we've got more important things to do, but this has not been at all helpful. One perhaps silver lining is the fact there is so much detail means that on some particular points, particularly on the individual cases, we can take the oral submissions very fast indeed. But the other problem has been they've all been produced far too late. There's been a certain amount of mutual blame as to that, but it seems to us there are faults on all sides. However, we are where we are. We don't want to hear explanations or apologies now. We want to get on with the case, but I warn you that this may be revisited at the stage of costs. That then brings me to the intervention application. Because of the time constraints, we do not propose to hear the intervention application now. If there is time at a later stage in the hearing, from what you told me you hope that there will be, I'm sure Ms. Knight hopes that there will be, Ms. Knight can make a bid to address us on particular points which she believes have not been adequately covered in the submissions to date. I think that sort of focused intervention, when we've heard the bulk of the argument, is likely to be much more helpful than having a debate now. And I think the same goes for the application to adduce further evidence.
Yes.
Not clear how much of that further evidence is really going to be referred to. If it is, we'll hear it de bene esse, and if there's a real argument about whether it's admissible, we'll hear it at that stage and be able to decide it in context. The one part of the further evidence which I ought to say something about is the recent Home Office report, which I think is one of the items intended to be put in by further evidence, though confusingly it also appears anyway, as it turns out, in the authorities bundle. The view the court proposes to take about that is that it is absurd, really, that we shouldn't be aware of it in general terms, and we either all have already read it or will have read it at some stage during the breaks in the hearing. But we will regard it only as background. If there are points in the report which appear to be significant and important, then we will give the parties the opportunity to address us on them. Lastly, we have given some thought to the shape of the issues. One point is that although there is quite a lot in the skeleton arguments about whether this or that point was taken below or is properly covered by the pleading grounds of appeal, in the circumstances of test cases, which is what these are, we do not want time to be spent on those sorts of points. We want to deal with every argument that we sensibly and fairly can. If they really are, if a point not taken type point is particularly important in the circumstances of an individual case, we'll deal with it in that context. It seemed to us that broadly, clearly the issues can be divided in different ways, but broadly they can be put under 3 heads. Firstly, whether these sorts of decisions can be properly made under section 3225, and if so, how, applying ordinary domestic common law, effectively public law principles. And there are a number of issues under that head. I would attempt to be comprehensive, but they include the range of section 322, the relevance of the guidance, the relevance of section 32, sorry, I should have said 3225, but there's also the relevance of 3222, standard of proof, procedural fairness, tame side, all those sorts of points. Then a second general heading, Article 8. Do these decisions interfere with Article 8 rights, given that they are not on their face removal decisions, they are merely the refusals of ILR. But also under that heading, what does Article 8 add to ordinary common law principles, particularly in the nature of any review? And the third is an essentially procedural point, which will only arise if Article 8 is said to be engaged, or is found to be engaged, but there are procedural questions about how, both in these particular cases and for the future, challenges to these kinds of decisions should be made, and the what may be quite tricky procedural points. Now, I'm not suggesting that any of you need follow that structure, but at any particular point, we will want to know where we are against that background, because there are times when in the skeleton arguments where the issues seem to range quite widely and you can't quite see where they fit in. Now, I know that's taken up quite a lot of time, but I hope in the interest of saving time more generally. Right, ready? Any points arising out of any of that, or we can go on straight to your submissions? Very well.
Thank you very much, Major, for that. Can I just say before I start, certainly from Mr. Albert's side, we do apologise. It may be sensible to deal with that in writing subsequently. I don't want to take any more time at this stage, but we do apologise for the various procedural problems that have been thrown up to the time. I won't take any more time.
No, don't take any more time on it. As you say, we can deal with it later in writing or in any other way if it proves necessary. Yeah.
So my lords, what I will cover is the following.
Oh, I'm sorry, just one more entirely practical point. I don't know if this is part of the much publicised IT failure in the courts, but the clock isn't working. I, I'm afraid, don't have a watch. If we get up to lunchtime and don't notice because your submissions are so interesting, don't be embarrassed to say so. Colleagues who are better equipped will do so.
I'll try and keep an eye on my wristwatch. According to it, it is 10 to 11, my lord.
Right, well, okay.
So Knowles, what I will cover in my submissions is the following. So firstly, the statutory and rule framework, just to set the scene. Secondly, the correct construction of paragraph 3225. Thirdly, Article 8. Fourthly, the standard of Wednesbury review and the approach to Wednesbury in its application in this context. Fifthly, procedural fairness. And sixthly and finally, any specific residual arguments in Mr. Balajigari's case, but I take on board my Lord Justice Underhill's observations that we may need to rely primarily on our written argument in that regard.
Thank you.
Mr. Singh will then pick up where I left off and deal with the tame side issues and HMRC's involvement and some other specific points which he's best placed to explain to you at the outset of his submissions. And I hope, my lords, that my submissions will cover at least a large amount of the ground that you've set out in terms of the three issues that you outlined.
Sounds as though they will. So off you go.
I'm grateful. So, my lords, turning to the statutory framework, the first point to note is that there's no dispute between the parties that we're dealing here with decisions taken by the Secretary of State pursuant to his broad power under Section 3, subsection 1 of the Immigration Act 1971. So the only point to note there is that we're not in the territory of precedent fact, unlike in the Arsan case. And of course the authority for that proposition is the Giri decision. I won't take you to it, but I can give you the reference for your notes, it's authorities tab 42, page 1354 to 1355, paragraph 32 of Lord Justice Richard's judgment. And of course that simply confirms that Wednesbury is the appropriate approach, although it's observed that a heightened standard of Wednesbury review is appropriate, and I'll come on to that when I get to the Wednesbury aspect of my submissions. The applications that have given rise to the decision-making challenged in these appeals were made pursuant to paragraph 245, capital C, capital D of the immigration rules, on the basis of 5 years continuous lawful residence as a Tier 1 general migrant.
So 245.
245, capital C, capital D.
Yep.
And they were applications for indefinite leave to remain, but on the basis of 5 years continuous residence, lawful residence as a Tier 1 general migrant. That provision can be found at tab 11 of the authorities, at page 219 to 220. In the interest of time, I don't propose to ask my lords to look at it because there doesn't seem to be much dispute, but that's the relevant context. It's also notable that Appendix A of the Immigration Rules, paragraph 19, deals with specific requirements as to the level of income that an applicant for ILR under 245CD had to demonstrate. Those provisions are also in tab 11 at page 223 to 227. And the short point to note at this stage is that paragraph 19I and 19J of those rules requires the Secretary of State to be satisfied on the balance of probabilities that the income relied upon is genuine. And 19J then lists a number of factors that the Secretary of State may have regard to in that inquiry. One of those factors, but only one of those factors, is essentially the history of claimed income. And so we would accept in principle that the fact that there's been an incorrect declaration of income to HMRC and or the Home Office is a factor that can be taken into account when assessing whether on balance of probabilities the amount of income claimed is genuine or not, but it's only one factor. My Lords, the general grounds for refusal are behind tab 10. Those are the general grounds for refusal in the immigration rules. So they're behind tab 10 in the authorities bundle. And paragraph 3225 can be found at page 212. Can I ask my Lords to turn that up? Bottom of 209, going over to 210, behind tab 10 in the authorities bundle, first volume. I'm so sorry. Bottom of 210 is where we start. Going over to 212, forgive me.
Yeah.
So bottom of 210, you've got the general grounds for refusing an application for leave to remain.
Yes, we all call it the general grounds for refusal. That's not actually. Is that actually a term that appears in the rules?
It is. If you look at page 205, this section, or this part of the rules, I should say, is part 9, and the title is grounds for refusal. Yeah. The reason that the shorthand general grounds for refusal is used is because these grounds for refusal apply across all categories of application, so they are genuine application.
Yes, and indeed under that heading they say general grounds. Yes, thank you.
But they cover applications for entry clearance, applications for leave to enter, as well as applications for leave to remain. And it's the part of the rules dealing with applications for leave to remain that are apposite specifically in these cases. And that brings us back to page 210, paragraph 322. So you can see that the general The structure of this rule is to set out the general proposition at 322, and then there's a subheading that immediately follows it, setting out underneath that subheading circumstances in which an application for leave to remain must be refused. So there's no discretion there. And if we turn over to the top of page 212, you can see the apposite subheading for our purposes, grounds on which leave to remain, etc., should normally be refused. So there's an acknowledgement of discretion, but there's a presumption, if you like, that the application will be refused. That's, in my submission, the correct way to interpret that subheading. And the two particular rules that are apposite for our purposes are 3222 and 3225. They've been line marked on page 212. Subrule 2 deals with a false representation or the provision of or a failure to disclose material facts in respect of a historic application for leave to remain, etc. And so that's a specific application. That's a specific application to cases where there has previously been dishonesty in an application for leave to remain made in the past. And subparagraph, or rule 5, I should say, 3225, middle of page 212, is in much more general terms, and my lords can read that provision to themselves.
That cross-refers to the previous page, to the sort of convictions that 3221C is referring to.
Yes, if one turns back to page 211, you can see that this deals with the mandatory back bar to an applicant,
I see.
to an application made in certain specified circumstances, basically where there's been a conviction.
Yeah.
And there's a tariff, if you like, of time that needs to be met
Exactly.
before.
So where it's not a mandatory ground for refusal, that's a conviction could be an example of where somebody is, because of their conduct, an undesirable person to permit to stay in this country.
Indeed. So we accept that, going back to 3225, page 212 of the bundle, the language is broad, but it's informed by its context.
And did you say that the reference to represents a threat to national security gives any kind of colour to this provision? Or is that simply an example of an undesirable person?
Well, this provision should be interpreted by reference to the language used in it, obviously, and in my submission, the fact that there is an example given of a particularly serious category of undesirable conduct suggests that we're dealing with a high threshold. So my lord, the answer is yes. But we accept that clearly paragraph 3225 is broad in its potential application, and I'll come on to the construction of 3225 if I may in due course.
Of course.
But certainly the reference to a threat to national security indicates that the threshold in terms of whether 3225 is available, it is high.
Just one other point. What is the relationship between 3222 and 3221A, which are both broadly to do with false representations or non-disclosure? I think, but I just want this confirmed, that 3221A is the very application with which the Secretary of State is concerned. So if you make false representations or fail to make a disclosure you ought to make in relation to that application, then the application must be refused. Whereas if it's in the context of a past representation, it's only will normally be refused. Is that the difference between the two?
Yes,
Right.
with one caveat, although it's not going to be significant here. 3221A is actually broader in application than 3222 in my submission. In this sense, but only this sense, 322(1)(a) covers the type of case where false representation is made, but not by the applicant, him or herself, whereas 3222 doesn't include that.
Oh yes, there's been some case law about that, but it's not what we're concerned with here.
So, so we know that for a 3221A application, it has to be dishonesty, although it could be the dishonesty of a third party. But in my submission, 3222 requires the dishonesty of an applicant. And there's good reason for that, because there's a good policy justification for refusing an application that has been corrupted by a false statement, whereas there's a less good policy justification for refusing a future application on the basis that an applicant has been, let's say, the victim of fraud in the past. But
Yes.
that's not something these troubles, if I may respectfully say so. It's also important to note paragraph 320 of the immigration rules, which deals with applications for entry clearance. 320 begins at the bottom of page 205, first page behind tab 10. So it's broadly in the same structure as with respect to 322 of the immigration rules, but it deals with applications for entry clearance. I'd ask my lords just to look at Rule 19, 320.19 on page 209. So in my submission, so I'd ask my lords just to read that rule. In my submission, 320.19 is part of the same structure, if you like, as 3225. So it covers the same territory, but in respect of applications by those outside the UK for leave to enter.
I think what you're really saying is that a person's presence in this country may not be conducive to the public good, even where they haven't got a criminal conviction, for example.
Yes,
So there's a broad area of discretion conferred on the Secretary of State to deal with a variety of situations, but we're all familiar from general knowledge of the sort of people who from time to time have been prevented from coming to this country.
Yes.
And one can understand that it is public policy that you don't have to be able to show that they've committed a criminal offence. It's just the fact that the Secretary of State doesn't think it's a good idea that they should be here.
Yeah, well, I accept that. So, it's no part of our case that you have to have a criminal conviction.
No.
But the reason I've taken my lords to 320.19 is to say that we're not just dealing with, we're dealing with a coherent structure. And it's important to note the language in 320.19, reference to conducive to the public good, which is of course the basis for a deportation decision. The example of where someone's entry into the UK would not be conducive to the public good is where it would be undesirable for them to be granted leave to enter. So it's the same language as 3225. And that's no coincidence in my submission, because 3225 would be of very limited utility if it allowed for an applicant to be refused leave to remain, but didn't. That applicant could then leave the UK and make an application for entry clearance, which wouldn't also be subject to refusal for the same reason.
Sorry, I may be being a little bit slow about that. 322.19 uses the language of conducive to the public good, which, as you say, is relevant also to deportation. 3225 doesn't use that language. It talks about undesirability.
That's right. If we go to 320.19, you can see the second sentence, which says, for example, and then we have exactly the language of something that's very similar to what's used in 3225.
Yes, I see. Thank you.
And of course, one reason for that may be that it was open to the Secretary of State, historically at least, to was the discretionary power to deport under Section 35A of the Immigration Act 1971. But if someone was seeking leave to enter for the first time, there'd be no power to make a deportation order, because deportation wouldn't apply if someone was outside the UK and had never entered the UK. At least that may be one explanation.
You're saying that we can and should have regard to paragraph 19, because the rules have to be construed as a whole,
Yes.
and that this does give some colour to what the rule maker had in mind when talking about undesirable in 3225.
Exactly, my lord. Yes. And it also shows that a decision under 3225 may have pretty extreme consequences, because presumably if someone's refused on the basis of 3225 and is then leaves the UK or is forced to leave by a removal decision or whatever, any future application would be refused on exactly the same basis but under 32019. So, my lords, just finally on the rules, I won't ask you to turn it up, but there's a helpful discussion of the general grounds for refusal and the way they operate, particularly in the statutory appeal context, in a decision called JC China, which is at tab 72 of the authorities, paragraphs 3 to 12. For my lord's note, that starts at page 2093. And what's important to note in my submission from that discussion is that these are grounds for refusal that the Secretary of State raises, and they're of general application, and for that reason the Secretary of State has the burden of proving that the rules are applicable.
That's a decision of this court, yeah?
No, my lords, it's a decision of the Upper Tribunal. Upper Tribunal Judge Story was chairing a three-judge panel, but it's been following many cases in the Upper Tribunal, and I don't think anyone would question it today as setting out a correct statement of principle. Moving swiftly on.
So just give me the tab number.
So that's tab 72.
Yep.
Paragraphs 3 to 12 of the report, which starts at page 2093, 2000.
Very helpful. Yep, thank you.
Moving swiftly on, my lords, a refusal of an application for indefinite leave to remain, such as those which have given rise to the decisions in these cases, is no longer appealable per se under the immigration rules. Under the scheme for statutory appeals, and that, of course, is uncontroversial. Under the current scheme for immigration appeals, it's only if there's a decision on a human rights claim that an appeal will arise, and that's clear from the terms of section 82, subsection 1 of the Nationality, Immigration and Asylum Act 2002. That's at tab 5, page 45. I don't propose to ask my lords to look at it. The remedy, though, that is available to a migrant who's refused indefinite leave to remain, where there's no right of appeal arising because of a refusal of a human rights claim, is administrative review, and the provisions governing the scope of and the procedure for administrative review are set out in Appendix AR of the immigration rules, and Appendix AR is behind tab 13 of the authorities bundle. Can I ask my lords just to turn that up briefly? So just to contextualise what's behind tab 13, the document that starts at page 247 is the version that's currently in effect. The document at page 254 is the version that was in effect up until November 2016, but certainly from the perspective of Mr. Balajigari, this was the version in effect at the time of the decision making in his case. It doesn't.
So 254 is relevant for our purposes, but you're about to say no real difference.
That's precisely what I'm about to say, and I felt it was helpful and important that the court had the current picture too. So if we stay with 254, if we look at page and go to page 255, you can see under the heading what will be considered on administrative review, the scope of administrative review under the rules, and of particular significance is paragraph AR 2.4, which limits the evidence that a decision maker can have regard to. Paragraph A identifies that new evidence can be submitted where there's a caseworking error of the type identified in paragraph AR 2.11 A, B or C. If we look at that briefly now, that starts at the bottom of the following page 256, going over to the top of 257, and you can see top of page 257, para AR 2.11A, Roman 1, general grounds for refusal on the basis of deception, essentially. So that's 3221A through 222, and the equivalent provisions for applications for entry clearance. but conspicuously absent in this list is 3225. We say that's a big problem when it comes to procedural fairness, not least because it's clear that the Secretary of State acknowledges that where there's an allegation of dishonesty as a basis for refusing an application under the general grounds of refusal, there should be an opportunity to put forward fresh evidence at the AR stage, but that logic doesn't carry over to the application of 3225, and we say that's an important part of the context when it comes to assessing whether the Secretary of State's AR procedures, administrative review procedures, are compliant with common law procedural fairness. I should also note, before I depart from this, that administrative review is also limited in other respects. If you look at the bottom of page 255, paragraphs AR 2.5 and 2.6.
Sorry, I just wanted to make a note to myself. Sorry, yes, where were you going?
So, my lords, it's paras AR 2.5 and 2.6, bottom of page 255. You can see that there's some limited possibility of a request for evidence, but only with respect to AR 2.11 A, B and C, so that doesn't help matters. But at 2.6, the point is made that there's no scope for considering a new basis for a grant of leave, if I can paraphrase like that. And I should say, for the sake of completeness, that under Section 3C of the Immigration Act 1971, an in-time application for administrative review in respect of an application that had triggered the extension of leave under Section 3C will itself generate an extension of leave until the AR, until an administrative review decision is taken. And that's Section 3C2, paragraph D.
That's presumably added by amendment at some point.
Indeed, in the Immigration Act 2014. So
one
can
3C2
D.
D.
So one can see the administrative review.
Sorry, it's using too little d. Or
Little d, yes. So one can see the administrative review procedures, if you like, as the successor to the old rights of appeal from a refusal of an in-time application for leave to remain. Now, finally, on the statutory context, I need to very briefly address the hostile environment. Where an application for leave to remain is refused in circumstances where it was made in time, then the effect of the refusal of the application is that the migrant becomes an overstayer. And of course, if there was an in-time application for administrative review for the reasons I've given, the point of time at which the person became an overstayer would be the decision on the application for administrative review by virtue of Section 3C. But at the end of that decision-making process, the migrant will become an overstayer.
sorry, this only a technicality. Suppose you have limited leave.
Yes.
And you make your application for ILR. Perhaps this would never happen in practice. Comfortably within the limit.
Yes.
And it is promptly refused. Does that effectively cancel your existing limited leave?
No.
Or, no.
There would have to be a separate curtailment decision. Of course, the Secretary of State could take such a decision on the basis that allowing the migrant to stay in the UK would be undesirable.
And logically, that's what they would do. But it's
That's
not a
what I
scenario that will happen very often because people apply towards the end of their limited leave, and we all know the decision doesn't
Certainly
happen
in the
very
cases
quickly.
that you and I see, my lord, that seems to happen. But it may be that actually there are many other cases where applications are later made
Right.
long before the
But in the typical case, their leave to remain will be dependent on the outcome of their application for
Yes.
ILR. Yep,
Well-
okay, that's clear.
in my experience in the typical case.
Mr. Biggs, forgive me for interrupting. Mr. Biggs, it may be relevant to my Lord's question, which is also in my mind.
Yes.
The provisions you've shown us in the rules about general grounds for refusal, as I understand it, apply to curtailment of leave as well.
That's exactly right.
So 3225, whatever it means,
Yeah.
would be something that could have a similar effect for curtailment decisions. Is that right?
Yes. In my submission, 3225 could be used as a basis for curtailing leave. and one would expect the system to allow for that, because if the Secretary of State says that your very presence in the UK is undesirable, perhaps because you're a terrorist or suspected of being a terrorist, one would expect that the Secretary of State would have power under the Immigration Act to end someone's leave and get them out of the UK.
So, in the untypical case where you've still got some limited leave left, if the Secretary of State is acting consistently, what you would expect is the refusal of the ILR to be coupled with a curtailment.
If the Secretary of State, and I say this with great respect, is acting as one would expect rationally in that very bland, undetailed example, if I can put it like that, then yes, one would expect a decision to end leave, because that's the logic of the assertion that someone's very presence in the UK is undesirable. So that brings me to the hostile environment and the Secretary of State's removal powers as they currently are framed. So the first point to note is that the refusal of an application such as the ones that have given rise to the decisions challenged in these appeals has the effect of making the applicant an overstayer. That means that they are subject to the Secretary of State's general power to remove, and we can see that from section 10 of the Immigration and Asylum Act 1999 as amended, which is at tab 4, and we've included at tab 4 the 3 versions of this provision which might be relevant, but in my submission the two versions are relevant, obviously. The first is at page 35, that's the current version, and you can see at the top that it's in force by reference to the Westlaw heading. And the way this works, my lords, and this will come as no surprise, is that there's no longer a need for a specific removal decision under Section 10 to be taken. Section 10 simply makes available to the Secretary of State provisions within Schedule 2 of the Immigration Act 1971 to give removal directions if someone needs leave to remain because they don't have the right of abode, but where that person doesn't have leave to remain. So, first point to note is that the decisions in issue in these proceedings have the effect of making the person removable, and indeed subject to the Secretary of State's power to detain under the Immigration Act, because that power is dependent on the Secretary of State's reasonable belief that the person could be removed. The older version of Section 10, which was considered in the Arsan case, is at page 41. And you can see that that provision was different. There had to be a specific Section 10 decision taken before removal could be effected. And Section 10(1)(b) was in issue in Arsan. The Secretary of State had the power to end leave to remain on the basis that deception had been used, whether successfully or not. And that the court accepted in Arsan was a precedent fact question.
Realistically, of course, there will always be a decision with a small d under the new Section 10.
Yes, that's
formally probably taking the form of removal directions.
Yes, and we don't have evidence dealing with this, but as I understand it, what the Secretary of State will do is serve a notice of removal window. So there doesn't. It may not be that there's actually a specific focused decision saying you're going to go at X time. There will be a window of time where the migrant knows that the Secretary of State is going to try to remove him or her. But the point is that in terms of the Article 8 arguments that I'll come on to, it's important to note that it's no longer part of the statutory scheme, that there's a decision that can be specifically targeted in terms of Article 8, in terms of removal.
Well, that's true up to I take your point. There isn't a decision like there was under the old Section 10.
Yes.
But once a migrant is served with a notice of removal window, they will clearly have a decision which they can challenge by whatever route is appropriate.
It can be done, my lord. I mean, there's two ways to do it. You could say, well, this is a decision which could be challenged, or you could say we challenge the proposed act of removal. It could be done one way or the other.
As a human rights, typically as a human right.
Yes, and of course the judicial review procedures allow for a challenge to an act, a proposed act.
Yes, right.
But it is important when looking at whether the decisions in these cases engage Article 8 to note that actually the effect of them is to make the person removable in a way which is closely analogous to what used to happen with a Section 10 decision accompanying a removal of leave, a refusal of an application for further leave. So that's section 10. The other consequence of the person becoming an overstayer is that they're subject to the so-called hostile environment. And this is something that if known from Ms. Nayak and Ms. Sada are permitted to advance submissions on behalf of an intervener, will be dealt with, I understand, to some extent by the intervention. I don't propose to take the court through the relevant provisions exhaustively, but if we turn to tab 9, you'll see a number of provisions within the Immigration Act 2014 as amended by the Immigration Act 2016 that give effect to the government's hostile environment policy. And it's worth just noting a few of the aspects of the hostile environment. The first is that, as we see from section 22 and its related provisions, that the migrant may not be able to rent property. So that's page 183 onwards. And landlords will be subject to consequences in terms of penalties, etc., if they do let to migrants who don't have leave. There's an immigration health surcharge that can be applied, so NHS treatment has to be paid for in a way that it wouldn't otherwise need to be. You can see part of that, the provision dealing with that at section 38.
Well, no, it's made by order, provided. Has such an order been made?
I understand, yes, although we don't have it in the
I think it'd be quite useful to pin that down, so if someone can get us the detail.
Are there any consequences for the migrants' children? For example, can they attend school?
I don't know the answer to that. I think they probably can,
Right.
but I don't know the answer.
All right.
You can see at page 195, section 40, prohibition on opening a bank account. So if you're a migrant without leave, and a legal migrant if you like, you can't open a bank account. And 197, section 40C, the Secretary of State can impose a freezing order with respect to a current, an existing bank account, etc. And similar provision at 198. Page 200, section 46, makes amendments to the Road Traffic Act 1988 with respect to driving licences.
Hang on one
Page
second.
200, my lords. Section 46, inserting a new section 97, capital A, which says that you can't get a driving licence. You can't get a driving licence if you're an illegal migrant, if you don't have leave and you need it. And section 47, going over leave, page 202, inserts new subsections into section 99 of the 1988 Act that allows for the revocation of a driving licence that's already held by a migrant. So, in my submission, it's clear that the hostile environment is exactly that. It is very hostile. It makes living in the UK extremely difficult, and indeed that's the very purpose of the hostile environment. In my submission, it's not too much of an exaggeration to call the hostile environment and the effect on a migrant's status a modern form of outlawry, because of course, although a migrant is still entitled to the protections of the law in our state, the reality is that they are treated very much less favourably in a number of very important respects. And we submit that's particularly significant when it comes to assessing the Article 8 issues. So, my lords, unless you have any questions, those are my submissions on the legal framework and the background and the relevant legal context. Can I turn now to the interpretation of paragraph 3225? We deal with this at paragraph 91 onwards in the joint skeleton argument, which I know that my lords have seen.
Yes.
We submit that there is a two-stage approach.
Just give me 1 moment while I get the...
Sorry, is this page 91 in the Bondo skeleton? Would you pay?
My lords have the bundle of skeletons.
No, I don't want to use the bundle of skeletons because I've only just got it. But
Yes,
right.
right.
What's the page in your skeleton?
It's paragraph 91.
Okay, thanks.
So it's page 30.
Thank
I'm
you.
very grateful.
Oh, is that right? No, I'm so sorry. It isn't. I was looking at the wrong skeleton. Trying to be helpful and not. It's page
24.
24.
24.
I'm very
I'm not
grateful.
sure it is. Wait.
I think there may be a problem with
There's an eccentric numbering system.
with the paragraph numbering.
Give us the page.
I'm afraid the copy I have has had the page numbers removed, so I'm using the skeleton bundle. If you'll just
Page
allow
19 in our version, I think.
It is it? Page 19. I'm very grateful.
Yeah, where the first paragraph 91 appears.
Thank you. It's under that. If you find
Yes.
section C,
Hang on 1 second. Yes, the odd reason the paragraph after 92 is 68.
yes,
So
I've seen that.
even the Home Office would be pleased with that as a piece of
Yes.
complicated numbering.
Well,
Yeah.
I apologise for that confusion, but you found it now, I think, my lord.
Yes, thank you.
And so we say that there is a two-stage approach. At the first stage, it needs to be decided whether 3225 is available. And at the second stage, the Secretary of State has a discretion as to whether to use paragraph 3225. And that goes back to the language of the subheading that we looked at earlier, which made it clear that there was a presumption that an application should be refused if 3225 is available, but nevertheless there was some discretion in the Secretary of State not to use paragraph 3225. And we submit that discretionary aspect of 3225 is important because it suggests that the use of 3225 is draconian and has consequences. At the first stage, so at the stage of working out whether 3225 is available, we submit the Secretary of State is required to demonstrate three things before 3225 is available. So the first is that there needs to be reliable evidence. The second is that there needs to be reliable evidence of sufficiently reprehensible conduct, which in this context we submit has to be dishonesty. And the third aspect of the first stage is that there then needs to be a balancing exercise of all relevant factors, both good and bad, when assessing whether, in light of the reprehensible conduct that's been established, it can be said that the person's presence in the UK is undesirable. And in my submission, that simply follows from the language of the provision, in particular, the use of the word undesirable, because undesirability requires an evaluation of all relevant circumstances to that question.
So you accept, in principle, that, for example, if somebody made a dishonest tax return, that could come within this provision. So it doesn't have to be analogous to a threat to national security.
Yes. So our submission is that if it's established by reliable evidence that someone evaded tax dishonestly, then that could get the Secretary of State into the second limb of the first stage. But there would still need to be an assessment of the question of undesirability. And that sort of misconduct would need to be weighed in the scales against any other positive factors and the circumstances overall when it comes to assessing whether there's undesirability. So if someone was an established terrorist in the UK, based, let's say, on secret evidence that couldn't be used to generate a conviction, but where the state was absolutely sure that someone was a very dangerous person indeed, then it would be unnecessary to look at, well, it would be less necessary to look at countervailing factors because of the strength of that side of the balance. But in the instant type of case, where one's looking at dishonesty in respect of tax returns, that factor is very much less weighty than others one can imagine. And so that suggests that the Secretary of State is facing a much more onerous task in justifying the conclusion that someone's presence is undesirable. My Lords, I hope that's clear. That's how we.
Well, that is clear. I just want to tease it out. There is a discretionary stage, which is the second stage, but effectively you're saying there's discretionary is perhaps not quite the right word, but an evaluative stage also as part of the first stage.
Yes, absolutely. And I'll come to the case.
So how do you decide which bits fall into which?
Well, there's a short answer. Everything that had to be assessed when rationally concluding whether the person's presence was undesirable doesn't need to be looked at the stage of discretion, obviously, if I may respectfully say so. But at the stage of discretion, there may still be other factors that weigh on whether the Secretary of State should use 3225, such as human rights considerations, such as the welfare of children, which of course are related to human rights considerations, but there's a separate statutory duty to take into account the best interests of a child in immigration decision making as a primary consideration. And there may be other factors too that need to be looked at, such as particular hardship that might befall a migrant by making them an overstayer and exposing them to the hostile environment, for example. So there is value and significance in this discretionary aspect of 3225 we submit.
Hang on one second. Another example possibly might be health conditions. It's undesirable someone be here, but they are very ill, and it would be inappropriate. Well, no, perhaps that's not likely to be a relevant consideration in an ILR decision.
Well, it might be, my lord, if the effect of the decision is to make the person an overstayer, and that means
Yes,
they can't afford any
Yes.
treatment. So one can think, if one spends time on it, of credible examples.
And just to come back to the first exercise, the assessment of undesirability, you accepted that in principle dishonest tax evasion might properly lead to a decision of undesirability.
Yes.
But you would always have to weigh countervailing factors.
Yes. And my lord,
Would it not be legitimate for the Secretary of State to have a general policy that anyone who dishonestly evades tax is undesirable, full stop?
2 points, if I may. That's not something I need to take a position on in these cases. And the second point is, it may be legal, may be in accordance with public law principles for the Secretary of State to take that approach, but of course that would be subject to the British Oxygen principle, that there would need to be sufficient flexibility in the policy. So if there was a blanket policy that all such persons are undesirable, irrespective of their particular circumstances, then that may fall foul of public law principles.
Well, yeah, I'm not sure, firstly, that this may not matter, as you said, but that may not be right, because a policy that tax evasion equals undesirability would still leave the Secretary of State with the discretion.
Well, I think, my lord, we're dealing here with the last aspect of the first stage, which is whether 3225 is available.
Yes.
So my lord is absolutely right, but in my submission, it's really important to bear in mind that last stage, the question of assessing undesirability, because it allows the Secretary of State to weigh the infinitely various circumstances that will arise in reality. So, for example, you can have someone who made a mistake in their life 10 years ago by dishonestly evading tax, but who's then become a reformed and glowing citizen who's brought an enormous contribution to the UK. And if the Secretary of State had a blanket policy that said, even in that situation you're undesirable, without looking at those circumstances, in my submission that would throw up serious difficulties in terms of the application of public law principles, and in particular the British Oxygen principle in Sanderford comes to mind. So in other words, that's my position. So can I just flesh this out by reference briefly to the authorities? I don't think there's any dispute that there needs to be a requirement of, well, I think there may be a dispute actually that there needs to be a requirement of dishonesty. In my submission, though, it's absolutely clear that dishonesty is the minimum that needs to be shown here to get into the territory of 3225, because anything else would not be sufficiently reprehensible. I mean, we're all capable of making mistakes, and negligence or even recklessness in my submission just isn't sufficient to meet the high threshold under paragraph 3225, and the authorities have taken that approach. So firstly, can I ask my lords to turn up tab 74 in the third volume of the authorities, a decision of Mr. Justice Collins that I think the Secretary of State relies upon, and it's paragraph 10 I'd ask my lords to look at very briefly.
You say tab 74?
Tab 74, internal page 2218, 2218. Paragraph 10 of Mr. Justice Collins' judgment on a substantive, in a hearing of a substantive claim for judicial review involving 3225, in this sort of tax context, the context that arises in these appeals. And you can see that Mr. Justice Collins is in fact, there needs to be
Shall we just read to ourselves what 10 and 11?
I'm great.
Yes, 11 actually don't really need, do we?
Well, I may refer to it later on, so
Yes,
since my
I
lord
see.
offered to look at it, I took my lord's offer up. The next authority, unless there are any questions arising out of this case, is the Khan case, Mr. Justice Spencer's decision in Khan. That's tab 65, and this is an authority the Secretary of State endorses for setting out the correct principles. That's tab 65. And we've line marked the relevant passages. Can I ask my lords to look first at the head note?
Yes, speaking, I think, for all of us, we've all looked at the head note. I suspect my colleagues have read the whole judgment, but so I don't think we need to read the head note.
All right, well,
Particular points you want to identify?
Can I just give you references to the rest of the authority? So it's the reference in the head note to the requirement of dishonesty,
Yeah.
and that's supported by para 32 of the judgment, page 1866 of the bundle, and also Roman 1 of the guidance at para.
So sorry, did you say 1866?
1866, yes.
And therefore para
Para 32.
para 32.
And then the guidance at the end of the judgment, para 37, 1872. But of course, those observations need to be looked at in the round against the entirety of what Mr. Justice Spencer was saying. But he's essentially, my submission, taking the view that if dishonesty can be inferred, but there needs to be a requirement of dishonesty. There is a requirement of dishonesty.
Yes.
And we don't object to that in principle.
He seems, forgive me, paragraph 32,
Yes.
one reading of what he says is that the mere fact that there has been an incorrect declaration previously can give rise to the inference that there has been deceitful or dishonest conduct.
Well, we don't, I'm grateful, we
Well,
don't.
forgive me, Mr. Biggs, but then he goes on to say he treats that as being prima facie evidence of dishonesty, and then he says that the applicant could present evidence to displace that. Now that appears to put the burden on the applicant to show that they have not been dishonest.
Yes.
Do you accept that?
No, we don't. And I was going to come to our response to Carl slightly later in my
Yes, thank
submission, but I can deal with it now.
No, don't take things out of order, please.
Sorry,
I'm sorry, just on the dishonesty point and Khan, it does have a requirement for dishonesty.
Yeah.
But what we're looking for is reprehensible conduct. I mean, it may be possible to have reprehensible conduct which does not include dishonesty, but as I understand this case, not in this context. So a mistake in or carelessness in a tax return or in the application, that doesn't get home on reprehensible conduct.
In this context,
In
that's
this
my
context,
submission.
yeah.
So my submission is there are a number of building blocks to it, but at the moment I'm dealing with the building block as to the requirement for dishonesty at a minimum.
Yes.
Yeah.
And that's, in my submission, really important.
Well, speaking, I think, for all three, in this context, it's hard to disagree with that. I suspect if there has been some cavilling of saying dishonesty is always required, there may be other forms of reprehensible conduct which are not dishonest at all. But that's not the area we're in.
You can be a deeply undesirable person, but deeply honest. A terrorist, for example, is
Well, quite. Or if someone is violent,
Yeah,
but for
sure.
one reason or another, you can't rely on a
someone
conviction.
has enormous integrity and honesty, but is trying to kill people in the UK, then they're undesirable.
Well, exactly. But if that is the only question about whether dishonesty is essential, I think that's
I'm great. But those are the
it's pretty obvious.
Yeah,
But in
well,
this kind of context, dishonesty.
I'm grateful. So my Lord's
Thank you.
with us on that. I think, as I said, I didn't at one stage think the Secretary of State was disputing that, given the endorsement of Khan. But as I read the skeleton arguments yesterday, I think they
Well, we'll find out when we
I'm very
hear from them. Yep.
in terms of the requirements for dishonesty, the court is going to be very familiar with how to approach dishonesty. But it may be worth just bearing in mind the recent decision of the Supreme Court in Ivy and Genting Casinos, where at paragraph 74 the civil approach to dishonesty was endorsed in that particular case. And in my submission, that would apply here.
Yes.
Just
I think
for
we
my-
need to go to it, do we?
No,
Yes,
but for my
very
Lord's
good.
note, it's Authorities tab 20, page 422 to 423 H to A. And the important point to note by reference to this authority is that there does need to be a careful evaluation of all circumstances bearing on the subjective mindset of the person who might be dishonest. And that is important for the Secretary of State to bear in mind when looking at 3225 in my submission in these cases, because that inevitably means that there needs to be a consideration of surrounding
Well,
circumstances.
maybe I was a bit hasty. I wouldn't mind just seeing that passage.
So, tab 20, page 422. So, bottom of page 42, paragraph 74, and you can see at line marking H, the sentence beginning when dishonesty. I invite my Lords just to read that part of paragraph 74 all the way to its conclusion at the top of 23B.
Yes, I see. Well, that's what I thought it said. I thought you were saying something going a bit further than that.
All I take from this passage is that the Secretary of State must be aware that there's a need to assess the subjective mindset of the individual
Yes.
and objectively determine whether that gives rise to dishonesty, given the concept of dishonesty.
Yes.
But that's an intense mental process in my submission.
I'm sorry, the focus of your initial submission was that you could have identified the mindset, the state of mind of the individual, but that's then set in an objective context, and you have to take into account all relevant circumstances.
Absolutely, my Lord. That's exactly right, and that's of course the approach that Lord Hughes is setting out. And we simply commend that to the Secretary of State when it comes to the application of the second limb of the first stage of paragraph 3225.
I think just to pin it down, why I thought you might be saying slightly more than you said here is that you were suggesting that it was peculiarly careful and complex to assess someone's dishonesty. Well, that will all depend on the case. There will be some cases where it is perfectly clear, and although you're always looking at what was in their mind, it will be perfectly obvious what's in their mind. Yeah.
But of course, the context here is of a dishonesty by reference by an inference arising from a mismatch in a statement of income, and that context needs to be borne in mind, and it does require the Secretary. So applying this approach, the Secretary of State would have to carefully consider the surrounding circumstances and assess the subjective mindset of the individual, and we submit that that may not have been done in these cases, or at least in some of them. So that's a requirement of dishonesty, and just finally on this, I would submit that requirement is supported by the approach in the AA Nigeria case, the Adedoyin case, which my Lord Justice Singh asked the parties to be prepared to respond to yesterday.
I think it was actually me, but
Was it? I'm sorry.
yes, when I reread it, it wasn't quite as close as I thought to the facts of this case, but it's still a helpful reminder. Thank you.
I mean, it's an important. Essentially, if dishonesty is required in that context, it should be required here when you look at the context and language of 325. That's my submission. If you want it's in the authorities bundle. It's tab 50, paragraphs 76 to 79.
I think it's a reported case. It actually appears in the unreported version. But
I'm so sorry if that's the case. I think there are two AA.
No, I'm wrong. You've got the report there.
The 2015 AA is only unreported as far as I'm aware. So
Thank you.
That's the potential confusion. So just to complete references, that's powers 76 to 79 in that authority, which start at page 1580, line tab 3. And so can I turn now to look at the authorities dealing with the requirement for the balancing exercise in terms of assessing undesirability. And there's one case that supports this, and that's the Ngawa Ngu case. That's at tab 61. And I'd ask my lords to read paragraphs 107, 110, and 120. That's tab 61.
Sorry, which paragraphs did you say?
107. That's at page 1776.
Yep.
110, following page.
Yep.
And 120 at 1779. Mr. Justice Foskett clearly takes this requirement to balance factors when assessing undesirability as an important aspect of 3225. Indeed, at 121, paragraph 121, he explains that the Secretary of State acted unlawfully by failing to acknowledge and apply the balancing approach in that case.
Well, let's just briefly read this. This is a case which is much cited, isn't it?
But by the appellants, yes.
Well, I didn't mean that, but I've seen it cited many times.
We say that's because it's helpful and correct, of course. Secretary of State may disagree.
We'll hear from the Secretary of State, but is it controversial that undesirability requires some assessment, some balancing exercise?
I believe it is, but I may have misunderstood. I think the Secretary of State says that Engau's wrong, that there's no balancing required, you can simply say dishonesty and leave it there.
As it were, dishonesty equals undesirability.
Yes. Now we say that can't be right.
It's not exactly that, actually, my lord. My lord, Lord Justice Singh will remember that within the public interest, in paragraph 276, to establish what the public interest is, it's not exactly a balancing exercise, but it is a process of assessment. So I would accept that you can take into account factors that go to whether there's a public interest in undesirability being the public interest, as it were. So it's not an Article 8 balancing exercise, but there is a process of assessment that means if you've got factors that go both ways, you take them into account
Very well.
when assessing.
Thank you. Well, you can develop that later. Thank you for that.
Yeah, of course, just to avoid any confusion or scope of doubt, we don't say it's an Article 8 balancing exercise.
No.
I think
You say it's inherent in the concept of undesirability
precisely.
that although there might be cases where the answer was obvious or where there were no countervailing factors, in a case where it wasn't so obvious, it necessarily involves a balance with a small b.
Yeah, absolutely. So there's always a balance. It just may be that one side of the balance is so overwhelmingly heavy that not much more in the way of reasoning is required. But that is certainly not the context in these cases we submit. Now, there are two recent authorities that have taken a different approach. These are decisions of the Court of Session in Scotland in OG and Dadsey. Can I ask, my Lord, just to briefly turn them up? Obviously not binding on this court, but I think they deserve respect. I respectfully say so. We say that those decisions are wrong for the reasons my Lord has put to me, which are that essentially undesirability, by its very nature, requires a balance to be struck and a range of factors to be considered. So those are at tabs 57 and 58. They're technically different cases and deal with different decisions, but the reasoning is essentially identical in both cases. So they were heard together, as I understand it. So if we turn to OG,
Sorry, these were out-of-house decisions.
yes. Yes.
First instance decision.
Yes, they were. So if we look at OG and DADSI, it's paragraph 28 in both. I think we only need to turn up OG, which is just the first authority in the bundle. It's tab 57, page 1670. And at paragraph 28, the court declined to follow the Engau approach of requiring a balance. In my submission, that's wrong for the reasons we've discussed.
Engau predated the 2014 Act
It did.
with the raft of measures that you've shown us
Yes.
about
Yes, I'm sorry.
about the consequences which now follow for a person. But these Scottish cases, post-date the introduction of the hostile environment.
And they're very recent.
But do you say that, if anything, what Mr. Justice Foskett said in Engau is now reinforced by the fact that we're in a different environment?
I'm so sorry, Lord. We say it's a fortiori. Yeah. I mean, actually, standing back and looking at this from a purely intellectual perspective, the correct approach to 3225 shouldn't really vary in terms of context, although its application will inevitably vary depending on the context. And we submit that the concept of undesirability inevitably requires a balancing of factors. But in assessing that balance, it is important to bear in mind the consequences, potentially, for a migrant of using 3225. Although it's important not to confuse that aspect of the first stage of 3225 with the discretion, which is a separate, distinct aspect of the Secretary of State's, of the correct approach to 3225 in my submission. And actually some of the cases conflate those two aspects of 3225. So there's a conflation in my submission between the assessment of undesirability and general discretion. That's an error in my respectful submission. It's important to keep those two things separate. But subject to that, my Lord, yes, I do.
I hadn't read these before now, but in paragraph 28, which I think is identical,
It is.
it's identical in the two cases. What Lord Tyre does is, he first of all looks at the undesirable conduct. And of course, we're not concerned about undesirable conduct here. We're concerned about the undesirability of the individuals present in the UK.
Yes, well, I hadn't analysed it that closely, but yes, that's right, and that's.
I mean, obviously, tax evasion is undesirable conduct.
Yeah.
But that's not.
That's not the right test. That's absolutely right.
You ought to have said reprehensible conduct.
Yeah, well, we use the word reprehensible conduct because that, in my submission, is the correct approach. Yeah. So that gets you into the territory of 3225. Then you have to balance that reprehensible conduct against all the relevant circumstances to reach a conclusion as to whether or not the person's presence is undesirable. And perhaps that's a particular reason not to follow the approach that was taken in paragraph 28 in this case. But we submit more generally that it's incorrect to say there's no balancing of factors required for the reasons I've discussed.
Does the word reprehensible come from anything that the Secretary of State has pronounced, either in the rules or in guidance? Or is that something that you've urged upon the court by way of submission?
I think primarily the latter, although I can't think immediately on my feet of the use of the word reprehensible. I may be wrong about that.
Yeah, I think one does have to be slightly careful about being too categorical, because, as you've shown us, the provisions that we're construing actually mirror provisions that apply to somebody who isn't here at all, but the Secretary of State wishes not to give entry clearance to. Now, it may be, and I don't want to go into specific real-life examples for obvious reasons, but just hypothetically, it could be that that person hasn't done anything reprehensible, certainly nothing criminal. It's just that they are, let's say, a member of Parliament of another country with the sort of views that the Secretary of State just does not think it's desirable for that person to come here and make speeches which might well create racial tensions or something of that sort in this country.
Well, I think
there has to be, would you accept, a very broad margin of discretion, in a sense, political judgment to be exercised by the government of this country in those sorts of cases. On the other hand, I think what you're really saying is, as my lords observed earlier, that in the specific context of tax issues, that what is required is dishonesty.
Certainly I endorse that. If I go back to the first part of my Lord's point, that may explain, my Lord's observations, which I don't derogate from, may explain why the language of 32019 is slightly different. Because it talks about not conducive to the public good, which is, of course, a broader way of putting the point. But then the example of where it may not be conducive to the public good to let someone in is where their presence in the UK is undesirable. Now, it may be that the concept of undesirability in other cases could extend beyond reprehensible conduct, but that's not the approach that we say is correct in these cases. I think it's probably worth just looking at the Secretary of State's policy actually on this, because I think there is some value to be gained from doing that. So it's tab 77, internal page 30.
Just before we get to there, I mean, the language of 5, and I appreciate my Lord was putting to you 32019, but the language of 5 is really a triad, or no, whatever it is when there are 4: conduct, character, associations, and threat to national security. And you could probably safely say conduct has to be reprehensible, even though character associations might not be quite the right word.
Yes, I accept that. Yes. My Lord, yes, my Lord. Character, I suppose, suggests something about a person's character which is reprehensible.
Undesirable.
Well, exactly.
Well, we could get lost in a wilderness of adjectives, but
precisely.
yeah.
So, but I think my Lord is absolutely right if I can respectfully say so. The conduct, the Secretary of State here relies on conduct, possibly character, though, but as we understand it, conduct, and that conduct has to be reprehensible. And that's supported by the policy that I've asked my Lords to look at, which is behind tab 77, internal page 2194. We've highlighted the key aspect of this.
Sorry, where I'm behind you, which tab?
So it's tab 77. This is the Home Office general guidance in effect at the relevant time. You can see just immediately behind tab 77, you've got the details of this policy, version 26, in effect from the 19th of April 16, and that's the version that applies here. It's been cited in the skeleton for that reason, and there's no derogation from that from the Secretary of State. And at page 2194, page 30 internal, you'll see the part of this document that's apposite for our purposes, or primarily so. And I'd invite my lords just to read the highlighted text. And this is where we get the requirement for reliable evidence from. But it also, in my submission, supports our point that there has to be sufficiently reprehensible conduct. But the expression sufficiently reprehensible is mine, but in my submission it's the correct way of looking at it.
So does that come from criminality, a threat to national security, war crimes or travel bans? Is that where you get the reprehensibility from?
Yes, but also in fairness to the Secretary of State, the following paragraph, where it's pointed out it doesn't need to be convictions. The key thing to consider is if there's reliable evidence to support a decision, etc. So it's put in general terms, but the context and language here, language to at least some extent, supports a requirement for reprehensible conduct, which we say in this context means dishonesty, as really all of the authorities below have acknowledged.
Yes, I mean the key phrase rather is that it calls into question their conduct.
Well, the Secretary of State has obviously good reason to use vague language. It's not well expressed.
No, I mean it so often happens. The guidance, it spans the language of the rule, but not in a particularly helpful way. The person's behaviour calls into question their conduct. That doesn't make sense, and their behaviour and their conduct's the same thing.
But the gist of what seems to be driven at least in my submission, is that there needs to be something pretty bad about someone to justify the conclusion that they're undesirable.
Yeah, there has to be reliable evidence.
Yeah, indeed.
That somebody's done something.
Exactly. Going back to my schema of the three limbs of the first stage of 3225, we say firstly reliable evidence, that's where that requirement comes from. Secondly, reprehensible conduct, in this context, dishonesty. Thirdly, balancing of factors so that there's a proper conclusion as to undesirability. Now finally, before I move on to Article 8, can I just deal with the second stage of the 3225 analysis about discretion? So completely separate from the first stage.
I'm so sorry, unless you want to put away 2194, I know no one's making a point about this, but I just want to mark it in case it's of any significance. Well, I've seen, obviously, many guidances now doing immigration cases. I've not before seen a bit where a section has been removed as it's restricted for internal Home Office use only. We just don't know what's said there, but nobody's asked, nobody's made a fuss. So.
Well, we've not made application for specific disclosure, although
Okay.
in fairness to my client, Mr. Balajigari, we were at the permission stage, so this may be explored if we go back down.
Very well.
So
Sorry, you wanted to make the point about the second stage.
Second stage, yes, just to complete this part of my piece. The Engao case is helpful on this as well. So can I praise my lord's indulgence and ask you to go back to Engao, which is tab 61. And at paragraphs 108 126 to 127, that's page 1780 to 1781. Mr. Justice Foskett looked at the argument that was presented to him that there had been a failure to exercise discretion because the Secretary of State had completely ignored Article 8 considerations. And albeit obiter, he accepted that submission. So that is supporting the authorities for a completely separate second stage where discretion is looked at. In my submission, that must be the right approach to take.
Sorry, I'm not following this submission. This is in the context of Article 8.
Well, if one turns to paragraph 126,
Yes.
the submission appears to, as recorded there, appears to have been that the Secretary of State erred in public law terms because she failed to take into account, she failed to consider Article 8 factors at the stage of considering whether, in her discretion, 3225 should be used. Now, with great respect to Ms. Mountford, who put this argument, I perhaps would have put things slightly differently, and because as I'll come on to in a moment, we say that we can directly challenge these decisions on Article 8 grounds. But what Justice Foskett appears to be reasoning here is that the Secretary of State had to acknowledge that there was a second stage to the 3225 analysis which required a consideration of discretion, and that second stage was vitiated because there was no engagement with a relevant consideration, which was human rights issues.
Yeah, I understand that, and of course it's helpful to have these first instance cases cited to us, but we may have to look at this as a matter of first principles, particularly because, as I said a moment ago, we're now dealing with the post-2014 Act context.
Well,
as I understand it, your fundamental submission amounts to this, that leave aside Article 8 for the time being.
yes.
As a matter of pure domestic public law, what the rule we're construing requires is a two-stage exercise.
Yes.
The first one you've developed at some length, very helpfully, if I may say so. The second stage is that even if you've got through the gateway where you can use the rule, you still have a discretion.
Yes.
And I think what you're submitting is that you can only lawfully use that discretion if you carry out a balancing exercise.
Well, but can I just, so what we say, so firstly the Secretary of State has to acknowledge that there's a discretion. Secondly, the Secretary of State has to then take into account any considerations which are relevant, so in public law terms, mandatory considerations, when assessing whether in his discretion to use 3225 even if it's available. And we talked earlier, I indicated earlier in discussion with my Lord Justice Underhill, the sorts of factors that could be taken into account, such as impact by reference to the hostile environment,
Quite.
and those sort of factors. So to be clear, we don't say that Article 8 is particularly significant at this stage, save that it may be that there are obvious Article 8 factors.
Forgive me for interrupting you. I'm putting out of my mind completely, for this analysis, Article 8.
I'm great.
Suppose Article 8 didn't exist.
Yes.
Right? I think what you're saying is that just the domestic rule, when properly construed, confers a discretion,
Yes.
and that the discretion cannot be lawfully exercised unless the Secretary of State, first of all, appreciates that he's got a discretion, and secondly, before exercising it, carries out a balancing exercise, because, well, for various reasons, but one of them may be that the refusal of the ILR application is, as you've shown us, not simply a refusal of ILR, it has potentially devastating consequences
Yes.
for a human being.
Yeah, my Lord, yes, I absolutely accept that. I'm grateful. I've avoided the use of the expression balancing exercise because, as I've indicated, there's a danger of confusion
Yes,
there. But subject to that caveat, absolutely.
I understand. Thank
But the other problem, I suppose, with the concept of a balancing exercise is that the structure of this is that the normal rule will be that it will be refused. I would see quite a strong argument that there's only any content at the second stage discretion if the case has some special feature to which normally the applicant would themselves rely, but might be apparent anyway, which calls for a departure from the general rule. So, although at some level of deep theory, you might still, I think my lord must be right that there'd had to be an appreciation there was a discretion to be exercised. If there was nothing about the case that took it out of the ordinary, I'm not sure a balancing exercise would be called for.
Well, I think that's right to an extent. I mean, the basis of the reason there's a discretion is because the rules say there's a discretion. So it's important, it's
Yes.
right that, my lord, as you put to me, my lord, that the discretion is not the discretion is not in general terms. There's a presumption that it will be applied, and I acknowledge that. But I think one can go too far with the application of that language in this context, because the Secretary of State has to acknowledge that this sort of decision, if it's used as a basis for refusing an in-time application for leave, is that the person is then subject to the hostile environment and all the other problems in terms of the possibility of detention and removal. And I think those factors should routinely be taken into account, albeit that it might be said that the policy balance has already been struck in that regard under the rules. So,
Yes, I mean, I suppose one could test it this way. Suppose we were looking at it pre-2014 when there was no hostile environment.
yeah.
What would your submission be? Would your submission be that even then, in every case, there had to be a balancing exercise?
Well, the submission is that there's a discretion, and that discretion has to be informed by a proper, when reasonable consideration of all relevant circumstances, or relevant considerations. Now, what a relevant consideration is something I don't think I need to get into, and it will depend infinitely on the particular circumstances of the case that the Secretary of State comes to look at. But generally speaking, at this stage, a relevant circumstance will be the impact of the decision, by reference to the hostile environment, in a case such as Mr. Balajigari's case, where the 3225 decision is used to end leave. Now, in other cases, such as my Lord's example of where an application is made perhaps right in the middle of a 5-year period of leave, those considerations would not need to be looked at because they're not relevant, because there's no suggestion, let's say hypothetically, that the Secretary of State would curtail leave and end the person's leave. So this does require a context-specific approach, but the important point to bear in mind is that there undoubtedly is a discretionary aspect here, and it does require the decision maker to have regard to all all relevant circumstances.
Well, I think you're saying then that in any case where it will end leave, at least since 2014, whatever may have been the position beforehand,
Yes.
there will always be a countervailing factor.
Yes,
So there will always have to be a balancing exercise.
I think that's right, and I think that's what my Lord Justice Singh put
Well, I
to
think
me.
he was, but I was just trying to explore it.
Yes, well, frankly, I hadn't quite seen it in such, if I may respect.
Well, it may be
so
wrong. It may be
clear
wrong.
terms, but I endorse that.
We need to think about this. But you see, the only reason I'm raising this as a question, at least to be thought about, is that sometimes in the arguments we've seen in preparing for this hearing, an analogy is being drawn with refusal of naturalisation.
Yes.
And at some point, no doubt, we'll be shown authority on how that's treated. But it might be argued that, important though those decisions are, stripped down to their essentials, what happens there is that you apply for the exercise of discretion to have a benefit conferred upon you. And if you're refused it, well, that's unfortunate. But one can stop there. Whereas I think what you're saying is that here, it's not just any longer simply a refusal of a benefit.
Yes.
Because of the 2014 Act, lots of other devastating consequences may follow.
Exactly. So now, to put it another way, we say that these cases are a fortiori fired. And I'll come to that in a moment.
But even before the 2014 Act, there would be some pretty serious consequences. I'm trying to keep away from Article 8, but effectively that you render yourself liable to removal.
That's right, although there was always...
And by definition in these cases, you will have been living here a long time.
Yes, that's right. And that's perhaps why Mr. Justice Foskett saw force in the reference to Article 8, because of course Section 6 requires the Secretary of State to act in accordance with the Human Rights Act.
But let's
Whether
leave Article 8 out of it for clarity
well,
of analysis.
I'm grateful.
I'm interested in this idea that we talk about the 2014 Act, but specifically the hostile environment provisions have made all the difference.
Well, they don't make all the difference in terms of the existence of the discretion or the public law principles that should be applied, but they must, in my submission, be a relevant consideration.
Yes.
And so in that
That's
sense,
really all you need say, but you do say, obviously, they make a big difference.
in these cases.
Yes.
Not conceptually. So can I turn then to Article 8? We deal with this from paragraph 34 to, sorry, 74. That's I think the second 74 to paragraph 117 in the joint skeleton argument. Essentially, we say the Article 8 issues are resolved by the answer to 4 questions. Firstly, does the appellant have Article 8 protected private life? Secondly, do the decisions challenged in these appeals engage that private life, or indeed family life, I should say? Thirdly, are the decisions in accordance with the law and proportionate? Essentially, the question is proportionality for our purposes. And fourthly, is there an adequate alternative remedy? I can deal with the first question in my submission very quickly. It's in my submission clear that these appellants do have Article 8 protected private and or family life here. My client has been in the UK since 2007 with leave to remain, and so up until the 20th of July 2016 decision, which is one of the decisions challenged in these proceedings. And so it's in my submission absolutely clear that he has Article 8 protected private life. And indeed, it's important to bear in mind that he was allowed to work in the UK and develop a career in the UK, and that's an aspect of his private life. The crucial issue in terms of Article 8 is whether the decisions engage Article 8. And we respectfully submit that they do. But before I come on to explain why, can I just make this point? The Secretary of State's position is, in my submission, strange, and I say that with great respect. He argues in the written argument that the appellants are arguing for some sort of quasi-appeals process or for the Secretary of State to be mandated to make decisions on human rights claims that have been made. In my submission, all of that is misconceived. The appellant's Article 8 argument is simple and orthodox. It's simply that in judicial review proceedings, a migrant can challenge particular decisions if they engage Article 8 on the basis that the Secretary of State is required under Section 6 of the Human Rights Act to act compatibly with the incorporated convention rights, which of course include Article 8. That's our case, and there's no reason, therefore, to be sidetracked by the Secretary of State's suggestion that somehow the statutory scheme might be undermined by allowing those judicial reviews, Article 8-based judicial reviews, to proceed, because that essentially amounts to an invitation to this court to disapply Section 6 of the Human Rights Act, and that, in my submission, is a very ambitious position for the Secretary of State to take. So can I turn then to the second question, which is whether Article 8 is engaged.
Sorry, we all use that as a shorthand, but to spell out what it means is, whether the Article 8 rights will be sufficiently interfered with, or interfered with sufficiently seriously.
That's exactly right. So my first port of call is the VW Uganda case, which is tab 53, paragraphs 21 to 22, a decision of this court, judgment of Lord Justice Sedley, and it's page 1615.
I'm sorry, which tab?
Tab 53.
Thank you.
Can I ask my lords just to turn that up very briefly? On page 1615, line marking on the side, paragraphs 21 to 22, and you can see here the context and the test. Consequences of such gravity as to constitute an interference. And the point that's made here by Lord Justice Sedley, by reference to his earlier judgment in AG Eritrea, is that there's a pretty modest or low threshold. No specially high threshold. We say that there are 5 There are three broad reasons why Article 8 is engaged in this case. In the skeleton argument, we've said there are 5, but I think on review, they can be perhaps more helpfully categorised as 3 reasons. The first is that the language and logic of paragraph 3225 and its place in the immigration rules schema means that these decisions have serious consequences and constitute an express or implicit decision that the relevant migrant should be removed from the UK and indeed excluded from the UK. When one looks at paragraphs 3225 together, paragraph 3225 together with 32019, we've looked at those provisions already, so I won't ask my lords to go back to them. So the logic of saying that someone's presence in the UK is undesirable must be that they should be removed from the UK, and indeed that they should be kept out of the UK, pursuant to paragraph 32019. Anything else in my submission would be irrational. So these are implicit removal and exclusion decisions, and we submit that there's a real analogy with deportation, which uses the language of conducive to the public good or not conducive to the public good, which we've seen is language used by the mirror provisions of 322.5, paragraph 320.19. Now, my lords will be very familiar with the language of the statutory power to deport in the Secretary of State's discretion, so I don't ask my lords to turn it up in the interest of time, but you can find it at tab 1 in the authorities at page 4, section 3.5a, and it talks about not conducive to the public good as a justification for deportation. So we say functionally, and this is relevant when it comes to looking at how Strasbourg would approach the issue, functionally this is at least very closely analogous to deportation.
Can I just pause there? This isn't a developed thought, but I just wonder if we can deal with it at a later stage. The back of my mind has been the line of authorities, I can't now even remember in quite what context they came up, but Daily Murdoch and so on, about distinguishing between a decision which will have the consequence, may have a subsequent consequence of removal, and an actual removal decision. Is that line of authorities a problem for you?
In my submission, no, for at least 2 reasons. The first is that line of authority dealt with a different statutory scheme, where you had to have specific Section 10 removal decisions. And the Secretary of State had a specific discretion that was therefore separate from decision-making in particular, in the context of particular applications for further leave, as to whether to remove. So because of that, there was an ability to coherently separate out the Secretary of State's discretion in terms of a use of, say, 3225 or some other reason for refusing an application and a decision to remove. So, for example, someone could be allowed to stay in the UK without leave, maybe on temporary admission, for human rights reasons.
Well, but I see, obviously, there is a difference in the relevant provisions, but the substance is the same. You've refused them leave to remain, but you have taken no decision with a small d, as I put it earlier, to remove. That may not happen for weeks or months. Indeed, the Secretary of State is rather chary about doing that. He hopes maybe that the hostile environment will mean people will go back voluntarily. So I'm not sure it's a complete answer to say that the statutory scheme has changed. You still have a distinction between a decision which makes you liable to be removed and an actual removal. So that was your first point. Yes. You may want to say something about that. What was your second point?
So my second point is that I respectfully agree with my Lord's observations, that the first point is not a complete answer. And so the second point is that the Daily Murdoch line of authority didn't deal with 3225 decisions. But a 3225 decision has to be, logically, when understood in context, a decision that the person's very presence in the UK is undesirable, which logically means that they have to be removed.
Remind me, what was the classic Daily Murdoch situation?
So the Daily Murdoch situation arose in the context of the old statutory scheme for immigration appeals, where practitioners had an incentive to say, perversely, one might think, looking at it simplistically, the Secretary of State should make a decision to remove someone, because if the Secretary of State did that, that would give rise to a right of appeal. Yes. And so there was argument that the Secretary of State should, when refusing an application for leave, also make a removal decision, and various arguments were advanced in support of that broad position.
And what was the case? Was Daily Murdoch? Was that Daily Murdoch the case in which it was finally sorted out?
Yes, in the first instance, and then in the Court of Appeal, and then in a case called Patel and Mercer.
That's right.
In the Supreme Court, it was all sorted out. My learned friend, Mr. Malik, appeared in that litigation, all of it, which is not uncommon. And so he may be able to assist further. But our short point, in our second point, in short, is that they weren't 3225 cases, and 3225 must mean a policy decision that a person shouldn't be allowed to stay in the UK. It's as simple as that, we say.
Just reverting to the first of those, which is that the mechanics were different. Under the Section 10 mechanics, the point of Daily Murdoch, isn't it, is that there has to be a separate decision after the legal decision, which was a Section 10 decision.
Yeah.
But with the Section 10 decision, were removal directions still has to be made.
Yeah, that's right.
Under the current scheme, you have a decision under 3225. What then has to be done to remove somebody?
Well, so the Secretary of State then has power to effect removal by the imposition of removal directions. But is there any difference then between
Daily Murdoch, the Section 10 decision, which was the crucial one then, and the paragraph 3225 decision now?
Well, as I say, there are two differences. One is the legal formalities and one is the substance. But dealing with, I think, my Lord's question, which is the legal formalities.
Yes, what you need to do after the...
Yeah, there is a difference because in the Daily Murdoch type situation, there's three steps that need to be gone through. Firstly, refusal of the application. Secondly, a separate removal decision. And then effectuation of that decision by the imposition of removal directions. And what the courts held in the line of cases starting with Daily Murdoch and ending in Patel and Mercer in the Supreme Court is that the Secretary of State had a separate discretion as to whether to remove in the first place. But in this case, that isn't the position in the sense that the Secretary of State has decided here, has taken the only step necessary to make the person removable. And when you add into the mix the language of 3225, which in my submission must mean logically that the Secretary of State is requiring the person to leave, because it just doesn't work for the Secretary of State to say your very presence in the UK is undesirable, but we're going to let you stay here anyway, particularly, if I may add this, when you acknowledge that 3225 is discretionary. So the discretion operates to focus the Secretary of State's mind on whether it's actually appropriate to try and remove at that stage.
But although they're different mechanics, isn't a decision under 3225 in effect a decision under both, in the old scheme, the application for leave and Section 10? It sort of takes over both, doesn't it?
Yeah, I mean, certainly I would be making the second point that I put to my Lords, if Section 10 had not been changed by the Immigration Act 2014. So the basic point would be 3225 mean that the language of 3225 and the Secretary of State's decision to use 3225 in the exercise of his discretion means that the Secretary of State is saying, I'm sorry, migrant, you've got to leave.
Which was the Section 10 decision
Exactly.
before, mechanically.
Exactly.
And Daily Murdoch said, well, you don't get an half-late go at the leave stage because you will get it at the Section 10 stage.
Yeah.
But in the current scheme, it's got to be, hasn't it, 3225 or nothing?
Yeah,
I mean,
absolutely. So 2 points there. Firstly, there is no separate stage.
No,
and secondly, it is 3225 or nothing on a proper understanding of 3225. And that's perhaps why the discretion under 3225 is important to bear in mind.
Because the only other in inverted commas decision is actually the imposition of removal direction.
Yes, and that's simply mechanical.
That's mechanical.
Yeah.
So, I know you said that your first point wasn't enough, but it might arguably be.
Well, this was put to me, and it gets right to the heart of matters, and I'm on my feet. So it may be that the 2 points are simply 2 ways of saying the same thing, or they're 2 sides of the same coin.
Maybe.
Thank you.
I'm very grateful. So I was just in the process of developing my point that these decisions engage Article 8, and I said there were 3 reasons. I dealt with the first of those, which is that there's an implicit removal or explicit removal and exclusion decision. That plainly is enough to show that these decisions engage Article 8. Indeed, as I say, there's a really close analogy with deportation. And there's no doubt that a decision to deport, even if there's no effectuation of that decision by a subsequent removal decision and removal directions, will engage Article 8. We know that from the Strasbourg authorities. I don't need to take time on that in my respectful submission.
No, but sorry, don't please.
The
What Strasbourg authority did you have in mind?
Well, well, for example, UNA, which just looked at a decision to deport, engaging Article 8 in principle.
Oh, I see.
And as I say, it's very
I see the point you're making. Okay.
And I suppose it's worth emphasising that Strasbourg will inevitably take a functional approach in terms of deportation, so the formalities involved don't really matter. What matters in my submission is removal and exclusion, and that's the way 3225 and 32019 operate. So that's the first broad point. The second point is this, that the consequences for a migrant of a decision to refuse an application for indefinite leave to remain, where that refusal puts them into the hostile environment and on the basis of 3225 are extreme and extremely draconian. So I don't need to repeat myself, but we've gone through the hostile environment already. It's also worth just remembering that the migrant becomes liable to detention and removal. And we submit that when one looks at the Strasbourg cases, these sorts of consequences are plainly enough to engage Article 8. So the first authority I'd like to turn to is a case called Sid Arbras, which is at tab 15 of the authorities.
$15.
15, 1-5. Just looking at the head note, just to orient oneself to the facts, you can see in the report at H1 and H2 there's a very helpful summary of the facts, page 281. Essentially, these were Lithuanian citizens who had worked for the government, essentially, interestingly, the Inland Revenue, and as a prosecutor, respectively, two applicants. But they were unable to work after the government had declared them as being to be former KGB officers. So there was a broad prohibition on the ability to work. And it was held that prohibition on the ability to work engaged Article 8 for reasons set out at paragraphs 45 to 50, which starts at page 294. So at paragraph 45, there's reference to the Smirnova and Russia case, which isn't in the authorities, but I'm going to hand it up in a moment. And you can just see, my lords, a summary of that case at paragraph 45. Perhaps has a resonance with the cases that are before you. And at paragraph 47, it was held that a far-reaching ban on taking up private sector employment does affect private life, so it does engage private life.
But this is not an immigration case at all.
No, it's certainly not, in the sense that...
I can well understand that in a non-immigration context, if the state imposes a restriction or prohibition on a person's ability to work in their own country,
Yes.
I could see that interferes with Article 8 rights. But immigration law, at its heart, is about, for example, regulating the labour market. Lots of people can't come into the country, or they can only do so on condition that they can't work. Are you saying that will always engage Article 8?
No. I think there are 2 points, if I may. It's not just the prohibition on the right to work here, it's the other consequences. And we know, although we don't have the authorities here, we know that in terms of Strasbourg, you can't discriminate against someone on the basis of their immigration status.
You can't unjustifiably discriminate against them on the basis.
No, I accept that. And obviously, it's important that the state has the ability to set immigration policy, and I certainly don't derogate from that or seek to. Well, I just don't derogate from that. But the other point here is that these were migrants who would be entitled to indefinite leave to remain, who are in the UK with leave, who would be entitled to indefinite leave to remain if the 3225 decision hadn't been taken. So if it turns out that actually they weren't dishonest or they weren't undesirable, they get indefinite leave to remain.
Yes.
And so
A
there
very
is...
similar point came up in our sound, didn't it?
It did, yes.
Yes.
So those are my answers to my Lord Justice Singh's observation.
Yes, thank you.
And you can see the way that this principle, confirmed at paragraph 47, is applied at paragraph 49. Because the barrier to employment impacted on their establishment of contacts with the outside world, both in terms of employment-related and other activities, that undoubtedly affects more than just their reputation. It also affects their private life, the enjoyment of private life more generally. So, my lords, we say that the instant case is a fortiori that, for the reasons I've discussed. Can I hand up this
Can I just...
spin-over case?
You can, but can I just be clear about this? You don't really need this second point based on the hostile environment if your first point is good. If this is tantamount to a removal decision plainly is a serious interference.
These are three independent reasons why
Yes.
Article 8 is engaged. If any of them are right, we win on the engagement issue.
Yes. Thank you very much.
I'm sorry, my lords. So perhaps if we can just insert this, I think tab 85 at the end of one. These paragraphs, well, can we start just looking at the head note briefly so you get the context? It's paragraph H2 it's the nub of the matter. So essentially what had happened was an identity document had been taken away from the applicant by the Russian authorities. And one of the arguments that was advanced, which was actually accepted, was that that did engage Article 8, and indeed Article 8 had been breached. And the reasoning for that conclusion starts at paragraph 95, internal page 15, paginations in the top right-hand corner.
Yes, how much of this would you like us to read?
Paragraphs 95 to 97, that's all my lords. And it's really 97 because it talks about the impact on the daily life of the person. And we say the hostile environment is a fortiori, simply holding back an identity document. Now, obviously, not an immigration case, but I've dealt with the significance of that earlier. So that's the second reason why Article 8 is engaged here. And the third reason is that these decisions plainly interfere with my reputation, which is an aspect of private life protected by Article 8. And that was confirmed by the Supreme Court in the Guardian case, which is at tab 31. Or rather, I should be clear, the fact that Article 8 protects reputation as a particular aspect of Article 8 private life was confirmed in that decision. And that's at tab 31. Paragraphs 38 to 41, which starts at page 953. contextualise this, this case concerned anonymity orders and the court's obligations in terms of balancing Article 10 and Article 8. But for our purposes, what's significant is that at paragraphs 38 and indeed 38 to 39 and 42 to 43 on page 9454, so that's 38 to 39 and 42 to 43, the Supreme Court clearly held that Article 8 separately protects a person's entitlement to reputation. And clearly we say a state-backed allegation of dishonesty as the reason for a conclusion of undesirability engages that aspect of Article 8. And that must be an independent basis, we say, for allowing a migrant to challenge a decision to use paragraph 3225.
It's not a necessary part of your case because you've got the other two, so perhaps it's not worth spending a great deal of time on it, but a state-backed allegation of dishonesty, it's not public in any way, is it?
Well, it is in the sense that this is a public decision. And what I mean by that is it's a decision that might find its way into the minds of other states. So it's possible that information is shared between states. I mean, after all, let's assume that a decision is made by the US authorities not to admit a terrorist. That information and the basis for it might find its way to the UK for good reason. So this sort of information might have consequences more broadly for a migrant. But of course, I don't need to go into that because clearly these decisions engage Article 8's protection of reputation.
Well, that's what you say clearly. I'm wondering whether every time the state makes a decision about you but doesn't publish it, it affects your reputation. On principle, I'd have thought your reputation is affected by things said publicly about you.
Yes,
Nobody knows that he's been refused.
I'm not an expert on the law of defamation or libel, but of course there needs to be publication to generate a cause of action at common law. In these cases, there has been publication. I mean, we're on TV. So the reality is, and there's been no anonymity. So that's not a point in my respectful submission that can make a difference in this case, although it might be a good point conceptually, quite respectfully says. So we say Article 8 is clearly engaged for those three reasons, and what are the consequences? Well, we say that in the light of recent authority, it's very clear that the appellants are each entitled to an effective remedy to vindicate their Article 8 case, and that Article 8 case will turn on a single focused factual dispute, at least as a threshold issue, and that single focused factual dispute is there dishonesty or not, if we write about the construction of 3225. Just as in the Arsene case, the allegation of, the basis for the decisions in Arsene was the allegation of cheating on an English test, i.e. dishonesty. We have exactly the same pattern of reasoning in this case. And so I just refer to my lords to paragraph 88 of the Arsene judgment, which is tab 39, page 1232. Paragraph 88. Thank you. Tab 39.
I had an idea Arsene was in the weekly law reports, but maybe I'm wrong. Someone should just check that over lunch.
Yes.
Yeah, maybe it isn't. 88.
Yes, so 88, page 1232, I'm sorry. Bottom of 1232, going over to 1233. Where my Lord, or Justice Underhill, accepted Mr. Nakatus's submission that in the cases before the court in Arsene, there was just one issue, which as a threshold factor at least, would determine Article 8. And the same applies in the instant case. If it turns out that the appellants were not dishonest, or indeed one further removed that they weren't undesirable, then there can be no basis for the interference with Article 8, and so the proportionality inquiry would be resolved in their favour. If it turns out they were dishonest, there may be need for a balancing of factors anyway, given other considerations. But I don't need to go that far in this case to show that there's an argument basis. effective remedy in that situation where the Article 8 case turns as a threshold on a factual dispute, in my submission, it's necessary to have a fact-finding hearing. And that's because Article 8's procedural aspect mirrors Article 6 standards, even in the immigration context. And we know that from this court's decision in the legal aid case, which is at tab 48, at paragraph 70, page 1495. I won't trouble my lords with it because I don't think there's any dispute about this, but that's the reference if you want to look at it. We also know that that's the position from Chiari and Binlos, even in the context of deportation of criminals, people who are established to have been guilty of serious crime. And the references there are tab 21, paragraphs 43 to 51 of our standard. Sorry, of Chiari and Binlos, at pages 440 to 443. And we say that answers the doctrinal question that my Lord Justice Underhill posed in the Carupen decision as to what the as to whether there may need to be a fact-finding hearing in order to afford an effective remedy in order to when one was challenging a decision on the basis that it could be charged directly by reference to Section 6 of the Human Rights Act. So the answer
just before we get on to that point, we've really slipped straight to remedy. But if you're right that Article 8 is engaged by a decision of these kinds, it's also applicable to the Secretary of State at the stage of his decision-making. Are you coming later to Article 8-based submissions about what the Secretary of State is required to do as a matter of procedural fairness? Or is it your position, in a sense, that that doesn't really matter, as long as, however unfair he is, you've got somewhere to go, which is the bit you're on now?
Indeed, Lord, it's the latter. So in terms of Article 8, we say that the correct position is as follows. In proceedings for judicial review in the Upper Tribunal or Administrative Court, a migrant can challenge the decisions such as those in issue here on the basis that the Secretary of State has acted contrary to Article 8 and therefore contrary to Section 6. That must be right in my respectful submission. Then there's a separate question as to, and of course it's well established that the court will have to decide for itself that question. I'm sure I don't need to trouble the court on that proposition. Then there's a separate question as to what the court will need to do in order to provide an effective remedy with respect to that Article 8-based judicial review. And this is the point that I'm on now. And we say
I understand you're on it now, but I'm sorry, I probably didn't make myself sufficiently clear. Are you going to be making any submissions about whether Article 8 imposes any obligations on the Secretary of State, procedural obligations, at the moment of taking his decision? I mean, maybe you don't need to. I just want to be clear.
I'm not making
You're
any
not.
separate
Okay.
submissions because I don't need to, but that may well be a point that should be explored, perhaps in a future case or whatever, but it's not something I'm prepared to deal with.
Fair enough. Okay.
Because we're challenging these decisions. And really what my client needs is a fact-finding hearing in order to show that he wasn't, or in order to put the Secretary of State to proof and argue that he wasn't dishonest. And so the question is he entitled to that? And we say he is because we know that Article 8's procedural aspect mirrors Article 6 ECHR standards in terms of civil disputes, if you like, civil law disputes, if you like. And that's clear from the legal aid case at tab 48, paragraph 70, which is at page 1495. I won't ask my lawyers to turn it up. It's also clear from Chiari and Binlos in the Supreme Court, tab 21, paragraphs 43 to 51, pages 440 to 443. And we say that fact-finding process so we say that in this context there must be a fact-finding process which allows post-decision evidence to be received, and indeed there should be oral evidence. So it's first, I think, helpful to look at the Manchester CC and Pinnock case, the Manchester County Council Pinnock decision, which looked at the demands of Article 8 in terms of its procedural aspect in a different context, in the context of evictions by local authorities. So that's at tab 30. And I just commend to my Lords paragraph 45. review of the authorities, the Supreme Court held that in the eviction context there was a right to a fact-finding hearing, so a de novo consideration of the issues. And there's no basis in my submission to distinguish the instant case from the line of cases that culminated in terms of domestic jurisprudence in the Manchester City Council and Pinnock case. The Secretary of State hasn't advanced any basis to distinguish that authority, and we say it applies in this context. After all, when one looks at the hostile environment, one can see that one isn't able even to rent property as a result of the decisions in question. The decisions are, if anything, much more extreme in their implications and effects than the decisions that were in issue in the line of cases considered in Manchester City Council. But perhaps more specifically, we have the Chiari and Binlos decision, which I'm sure my lords are very familiar with, so I won't ask you to turn it up. But at paragraph 76 in Chiari and Binlos, tab 21, page 451-2, the Supreme Court held that there was a requirement in order to have an effective remedy in terms of a challenge to deportation on Article 8 grounds for oral evidence. And if anything, the instant case is a fortiori that, for the reasons I've set out, which I hope are obvious, so entitlement to ILR, exposure to a hostile environment, disputed allegation of dishonesty, which is intensely fact-sensitive, etc. And similarly, in Arsan, at paragraphs 88 to 92, again, I won't ask my lords to turn it up, the reference is tab 39, page 12340 to 1235. It was held that a migrant was entitled to an in-country judicial review on a full fact-finding basis because oral evidence was necessary in order to respond to an allegation that there was cheating on an English test, which was the only basis for a decision to refuse to remove a person. And in both Chiari and Binlos and in Arsan, Parliament had given a right of appeal, but it was only exercisable when a migrant had left the UK. In the instant case, there is no alternative remedy at all. So the instant cases, we say, are a fortiori. So, in my submission, it is clear that Mr. Balajigari has an arguable case for judicial review at the very least. It can't sensibly be said that there's no realistic prospect of success in his case in terms of Article 8 because of the intensely fact-sensitive nature of the Home Office's allegation and all the other circumstances. Now, it might be necessary at this stage to deal with my application to reduce new evidence because that's the only reason that we seek to put in new evidence. It's simply to show to the court in detail the sort of evidence that Mr. Balajigari would want to put forward at a fact-finding hearing if the matter were remitted to the upper tribunal. Because in Mr. Balajigari's appeal, unlike in the other cases, we're at the stage of permission. So there would be, and my submission should be, a further hearing in the upper tribunal which will proceed on a full fact-finding basis in order to vindicate my client's procedural rights under Article 8. And it can't be said in my submission, and I don't understand the Secretary of State to say it, that there is no real prospect of success in my client's response.
Yes, I see. So it would only be necessary if you succeed on the points of principle, which means that the judge do not approach it in the right way.
Yes.
But Ms. Anderson or Mr. Malik, would be Ms. Anderson, were to say, yes, but don't send it back because it's hopeless on the facts. Is that right?
That's absolutely right, but Ms. Anderson doesn't make that submission, and if she did, she'd be wrong. Because even
well, she isn't leaping up to say she does make that submission, and if that's all we need the evidence for, let's just park your application. If unexpectedly, at the end of her submission, she does make that argument, we'll revisit it.
I mean, I should say that there was, albeit it wasn't admitted into evidence by Judge Gleeson below, there was what we say is an admission by the accountant of the mistake and a brief witness statement which certainly set out, endorsed by a statement of truth, the appellant's denial of any dishonesty in his reference to the accountant's mistake before Judge Gleeson. It wasn't admitted, so that was in the upper tribunal. But we say, just looking at these allegations as a matter of generality, and these types of decisions as a matter of generality, it will be very difficult for the Secretary of State to say that there's no realistic prospect of success at a fact-finding hearing because of the nature of the allegation, etc. So, for those reasons, we say the Article 8 arguments are absolutely sound and work, and in Mr. Balajigari's case, the matter should be sent back to the upper tribunal for a substantive hearing on that basis. Briefly on alternative remedy, we accept...
Now, let's just see, last time I checked, it was nearly 1 o'clock. What time is it now?
It's 2 minutes or so to 1.
How long are you going to be on alternative remedy?
Very brief.
All right, we'll hear you on that.
Maybe not 2 minutes, but certainly I'll be very brief. In principle, we accept that there could be an alternative remedy here in the way that my Lord Justice Underhill sets out in Arsene, powers 115 to 121. But the requirements for an alternative remedy here have not been met because, for whatever reason, the Secretary of State has not agreed to that Arsene procedure. But in the future, we say that the Secretary of State should agree to that procedure because that affords a sensible mechanism for Article 8's procedural aspects to be satisfied, and for migrants in the position of Mr. Balajigari and the other appellants to have the opportunity they need to respond to these very serious decisions. That's my position in terms of alternative remedy. So I was
less than 2
less
minutes.
than 2 minutes.
Well, now how are you doing?
I finished Article 8. The rest of my submissions will be pretty quick. I think I'll need another...
Well, you've been, if I may say so, you've been admirably concise without being hasty. So you're on target.
I think I am, yes. I understand Mr. Singh may need an hour or an hour and a half for his submissions.
An hour and a half at least.
Well, let's see, Mr. Saini. I think we may look again at your skeleton over the adjournment. Expect a certain amount of analysis of how much we really need to hear from you.